Hey guys, it's Kathy. I hope you're doing well. So a little later night stream today because I was working on my food truck today. So priorities. I had to get that done. And it's getting freezing out there. My hands were numb. So today I got some inmates that are very, very unhappy. Very unhappy. Mostly with their own lawyers. The poor lawyers, they do try. I mean, I understand. I do get it. They have a big caseload. So, they only have X amount of time. But that's all they need. They know what's going to happen to the case. They know what they can get. They know what they can't get. I know every inmate wants their lawyer to like Perry Mason them out of there. But I mean, that's just not the way life goes. If you commit a crime, your lawyer is going to get you the best deal that they can, but you still committed a crime, right? You're going to get punished for it. But they don't want that. And a lot of them use like mental health as like a get out of jail free. And I think some of them think that if they can just get into a mental health facility, then they don't have to do jail and that's better for them. And it's just not. I mean, have you ever been to one of those facilities? It's rough. It's rough. But let's start with a great, great judge. Magistrate, I think. I'm sure. Okay, I'm 82.5% sure it's a magistrate judge. Here we go.
Be Brandy Curtin.
Oh, yeah. Go back again.
Yes. Ms. Curtin, you were charged with use of possession of drug-related objects and possession of a Schedule II substance, crack cocaine. Do you understand your charge?
Yeah.
I can't hear you.
Yeah.
Your bond for the first charge is $1,000. The second charge is $5,000 for a total of $6,000. And you shall not violate any laws or out on bond. Do you understand?
I don't. What you say about the prices of the bonds?
The $1,000 for the misdemeanor and $5,000 for the felony for a total of $6,000.
It shouldn't have been a felony though. They
Let me stop you.
Huh?
Because you at the beginning of the line, and I don't want people to see what you're doing and then start following suit. I've already explained earlier. Stop. I've already explained earlier. The purpose of this hearing is not for you to give me your defense. The purpose of this hearing is for me to tell you what the charges are. If you don't understand your charges, I'm happy to read them to you, ma'am. But it sounds like you're about to go into legal defenses about what the charge should or should not be. That's not appropriate for today. Do you understand now?
Yeah, can I give?
Don't say yes to me. The answer is yes or yes, ma'am. Okay. So the answer to my question is yes. You understand?
Yes.
Okay. Now, do you have questions about the nature of your charges? If so, I'm happy to read the allegations aloud for you to understand what they're alleging.
No.
Okay. Now, as I mentioned earlier, your total bond is $6,000, and a condition of your bond is that you shall not violate any laws by out on bond. The question I asked you earlier that you did not understand was, do you understand those special conditions? Now, do you understand that?
Yes.
Are you able to make bond?
I'll try though.
I understand, ma'am. I have appointed an attorney to represent you. Your next court date, should you not make bond, will be January 29th at 8:30 a.m. Have a good day.
Let's go, Ms. Curtin.
Mr. Nolly.
Hi, Your Honor.
Hi. You are charged with battery. Do you understand?
Correct.
It was initially charged as a misdemeanor. However, in line with the statute, based on the fact that you have a conviction from this year of the same offense, battery, family violence, that charge now becomes a felony. Once that charge becomes a felony, the court has to review to determine whether or not you qualify for bond. And the rules say that if you have a felony and you're currently on probation, the court cannot authorize a bond. So you do not have a bond in this case. Your next court date, should you get a bond, rather, you shall stay away from Marche Row, and you shall not return to the shared residence. But as such, based on the fact that this is our felony offense, you do not have a bond at this time. I am going to appoint, do your children live with you, those 4 children that you mentioned in your application?
Live with me.
They
But
don't?
I take care of them.
Based on the fact that you said that you take care of them, I'm going to go ahead and appoint an attorney to represent you. You're kind of on the line, but with you having 4 children that you help support, you likely will qualify. So I'm going to go ahead and appoint an attorney to represent you. Your felony court date will be January 29th at 8:30 a.m. Have a good day.
Is there any questions? I thought that you would ask a question or ask me a question or say if I had any questions.
Do you have any questions? What questions do you have?
Can you make sure that probation comes to see me, please? That's all.
That's not my job. I have appointed an attorney to represent you. Your attorney can talk to probation about coming to see you or seeing if they want to release the hold or whatever. So absolutely, I have an attorney that is their job to advocate and see can probation come to see you, but that's not my job to order them to come see you.
Okay, thank you so much. Just one last statement. I don't agree. It didn't happen last time.
Do you have a question for me? Let me stop you because you've been here all day. Put your hand down. If you have a question about anything I've shared, you can certainly ask it. If you're about to go into a defense, it's inappropriate and I'm not going to allow you to do that. So do you have a question about what I've shared with you?
Yes, I have a question.
What is your question?
Will it be taken care of? Will the things that need to be, that you said, that I swore to earlier to be true, that the attorney is going to represent me properly and that is going to do the job to research for that probation officer? I don't agree with it, but I want that to happen. I just want to know from you, will that happen for me? We have
very good public defenders and court-appointed attorneys.
Yes, we do.
So the attorney that I'm appointing to represent you will receive your information. They'll get it. They don't work on the weekends. They'll get it first thing Monday morning. They'll review, and based on their policies and procedures, someone should be out to see you as far as your attorney. And your attorney will start to work with probation to see what needs to happen.
Thank you so much.
You're welcome. Have a good day. For Stacey.
So I have a disclaimer. If you hear noise in my background when I'm not muted, my son's home from college. 20-year-old son, you would think in college would act like an adult sometimes, but no. He's a gamer. He actually got a scholarship that pays for his college because he plays video games. So I have to let him play video games. I don't have a choice. But he's very loud. He screams, he yells, he pounds. And it's not, even if I was abusing him, listen, it's not child abuse because he's 20 years old. So you could call the police on me, but it would only be assault if it was me. So there's no child abuse going on in this house because he's 20. All right. I'm trying to think if I already showed you that clip that I just showed you because when my computer broke, I had to transfer those files, the clips that I already had, to my new computer, and I am not the most organized person in the world by far. So like I transferred them really badly. So I might have played that one twice, but I don't think there's any more that I'll play twice, don't worry. But if there is, just fast forward. You have a button right there. Just fast forward. All right. This guy wants a new lawyer, guys. Shocking, right? So right now, I'm just going to say, the audio's fine. Right now, it's not. He's just saying he's away from the microphone. And he's saying that this guy wants to speak to the judge first. So that's all you're missing.
What's your name?
Bernie Harris.
Bernie Harris is on page 7 of the docket. Mr. Harris, you're here because you have a trial set for Wednesday or Thursday, I guess it is, Thursday the 14th, on the charge of assault on a first responder. And then you also have charges that are set for trial: resisting arrest, implied consent, DUI, reckless endangerment, reckless driving, evading arrest, driving on a license, revoke, and assault on a first responder. And today is your plea date, which means that unless you settle your case today, your case will go to trial either on the indictment. You'll either have to plead to the indictment or go to trial. So what is it that you're saying you wish to have me?
I wish to have another attorney. I don't believe that Mr. Taylor has my best interests in mind. If you could appoint me another attorney, or if you could lower my bond to a reasonable amount, I could get out and get my own attorney.
The trial set for Wednesday of this or Thursday of this week.
Off another couple months.
What's your reason for saying that you think Mr. Taylor
done absolutely nothing for me? It's just taking the first thing that the DA has offered and says that should be good. He hasn't looked into any of the video or anything that I suggested. He hasn't checked with my therapist to go see my medications or anything. I just believe another attorney would do a better job. I believe a paid lawyer would do even better if I could get out and get my own. But if not,
having a paid lawyer, you've got a paid lawyer. The difference is that the public defender's office is paid by the state of Tennessee to represent indigent defendants. And therefore, if I were to relieve Mr. Taylor as your lawyer, then I would simply either have to appoint some other private attorney who would then be required to represent you for far less than they would normally charge someone else. The fact that you don't like what he's telling you is not a basis for me to discharge him as your lawyer and to allow you to have a different lawyer. Mr. Taylor, are you ready for trial?
yes.
Going to trial. Pardon? All right, you're going to trial Wednesday, Thursday, I think the 14th. Thank you. We'll see you in trial. Your motion to discharge your attorney is respectfully denied. 37, and that's the resisting and stop arrest, implied consent, DUI, reckless endangerment, reckless driving, evading arrest, not driving on a revoked license, and assault on a first responder. All right. Trial will be on the 14th. Thank you.
So he doesn't like the job his lawyer is doing, but you know, he was free to hire a lawyer on day one. No one stopped him. He says he can't because he's incarcerated. Yeah, you can. I know a lot of incarcerated people who get a lawyer, like a lot of them. So his trial is Thursday. Today is Tuesday, and he wants a new lawyer because this guy's not working hard enough. He took the first plea deal that was given to him. That's because he knows. He knows that's what he's gonna get. That's just how it works. This guy did a lot of bad things, especially in assaulting a first responder. It's not, I don't even think that it was assaulting an officer. It was assaulting a first responder. People who are only there to help, period. That's all they're there for. So we'll see. I should get his case on Thursday if it's good. I mean, his lawyer's going to talk the whole time, so we're probably not going to hear from him again. But this guy right here, the end is the best. The end is the best part of this next video.
And I don't have statute numbers.
Find something on
It takes a second to get started, but I left it in here so we can watch him hold up his little piece of paper to try to get everybody's attention.
Well, this one doesn't say one way or the other. It just says no person shall knowingly authorize or permit a motor vehicle on by him or under his control to be driven by.
They're talking in the background. That's why you can't hear it. So don't worry. We'll hear it better soon.
2/7.904.
No, 326.
7.904 to 257.904 nearly mirrors that. Person shall not knowingly permit a motor vehicle owned by the person to be operated on a highway or other public place open to the general public or generally accessible motor vehicles. So forth.
I think you might want clarification because, like I say, one is reasonable and one is not.
Well, the clarification would be that I did discuss with Mr. Wiles, and it was his intent that this one is not abstractable. So let me send him a text. Go ahead to see Jennifer.
Thank you. Okay, we're going to move over back to the jail then. Good afternoon in the jail. What is your full name, sir?
Jerry Ridgway.
Ridgway, do you have, what's your full name, sir?
Jerry Jerome Ridgway, Jr.
So you heard it correctly. It's Jerry Ridgway, not Gary Ridgway. And only a few of you will understand that.
Junior?
Your Honor. Yes, ma'am.
Thank you. All right, this is case alleging a fugitive from justice. Ms. Conlon, here is your agreement attorney to see you through this first hearing with the court. Ms. Conlon, if you had an opportunity to speak with Mr. Ridgway regarding the charge, the possible sentence, and his rights.
Well, Your Honor, the possible sentence would be being extradited. So we did discuss that. But yeah, we did discuss his right to have a hearing and to have an attorney represent him at that hearing. He is going to exercise that right and is requesting that the court appoint an attorney to represent him for the extradition hearing. And then he also does wish to be heard on bond once that's completed, Your Honor.
All right, Mr. Ridgway, please raise your right hand.
Yes, ma'am.
You solemnly swear and affirm the information about to give is the truth, and nothing
Yes.
but the truth.
Yes, Your Honor.
I will ask you some questions for the court-appointed attorney you requested, and also for bond on this. You can put your hand down now, thanks.
Yes,
You
ma'am.
put your hand down.
Okay.
All right, are you renting, buying, living with parents, or paying room and board?
You say what, ma'am?
Are you renting, buying, living with parents, or paying room and board somewhere?
Living with parents.
And where are you living with parents? What's the address?
135 Pine Ridge Road, Buffalo, New York, 14211.
14211?
Yes, ma'am. And I was just released from a mental health hospital. And I was supposed to be doing outpatient.
Where were you at this hospital?
I was in the address is 18001 Rotunda Drive, Dearborn, Michigan. It's called Beatmont Behavioral Health. I was there for 2 weeks. I was inpatient.
Okay.
Yes, ma'am. And they wanted me to seek out. Huh?
And then what did they want you to do?
I was just released a few days ago, and they wanted me to seek outpatient treatment, but then I had police contact, and they told me I had a warrant in Wisconsin I never knew about. I'm not a flight risk. You know, I was trying to see if I could get released.
How did you get to Traverse City, sir?
Because I was told that they have better mental health hospitals out there, and I wanted to come to see if it was better than the one in Dearborn, maybe.
So you came up here and got arrested? Is that what happened?
Yes, the police just ran my name and told me I had a warrant that I never knew about. And I was seeking treatment. I was about to go to another mental health hospital out here. And that's what I'm asking you. Is there any way I can get released to a mental health hospital so I can continue my treatment instead of being in here, because they're not helping me in here? I don't get no medication for my delusional thoughts or nothing. They just leave me in here. And I was just asking you, you say what, ma'am?
I said, thank you for that information.
Yes, ma'am. Treatment is not that I'm running. I'm not a flight risk. I'm really like seeking mental health treatment. And I was in this hospital for like 2 weeks, ma'am. And they was giving me medications, counseling and everything. But now that I'm in jail, this is not helping at all. They just leave us in the cell all day. Is there any way I can get released to a hospital so I can continue my treatment? Instead of being...
We're going to discuss that in a moment, okay, sir?
Thank you so much, Your Honor.
Thank you. All right, Ms. Conlon, did you explain to me the usual circumstances behind a fugitive from justice complaint?
Yes, I did, Your Honor.
All right. Well,
I'm just trying to seek treatment, Your Honor. I'm not trying to run from the law or nothing.
All right, let's talk about your request for court-appointed attorney first, all right?
Yes, ma'am.
Let's take one step at a time here.
Yes, ma'am.
All right, are you single, married, divorced, or separated?
Single, Your Honor.
Never been married. Do you have any children?
Yes, my son, he's 16 years old.
And does he live with you?
Yes, he actually lives with my mother. She's taking care of both of us actually right now.
All right, so he lives in New York.
Yes,
were
ma'am.
you working? You were not working because you've been an inpatient?
Yeah, I was inpatient. I was supposed to go back to the mental health hospital.
Do you have
and they was gonna take
income?
No source of income right now, ma'am. That's why I was trying to get back into this treatment. Maybe they can help me.
Okay. Do you own a vehicle?
No, ma'am.
Do you have any money in your bank?
No, ma'am. I just only have $100 in my account. That's it, Your Honor.
All right. We're going to appoint an attorney to assist you through the extradition process with the court. You'll be receiving information on that. Now, as far as bond goes, when we have a fugitive from justice and there is a governor's warrant, those are generally speaking no bond situations. So you will not be given a bond at this time. However, we will request that we expedite your extradition hearings.
And how long would that take?
We're going to expedite, and it'll be up to the judge and the recorder as to when that will be set.
Is there any way I can get released to a mental health hospital to continue my treatment?
Not at this point, sir.
Can you tell me what the charges are for?
So this is a fugitive from justice situation out of Wisconsin. When you have your attorney will be working with you on this.
And you said you're going to expedite it?
That's right. We're going to request that they expedite your hearing so that we can get you back into treatment, okay?
Okay, thank you. Back into this hospital, right?
Wherever the treatment is, we will try to expedite it for you.
And so I got to talk to my attorney about that, right?
Yes, you're going to talk to your attorney as soon as your attorney contacts you. And the attorney will know where you are.
And he can get me back into this hospital?
I can't guarantee you where you're going to be going for treatment, sir. You simply talk to your attorney and he will assist you as best he can to get you where you want to be.
How long would I be here? You don't know?
I do not know. We're expediting your hearing.
Thank you, Your Honor.
You're welcome.
So no PR bond for me?
No PR bond.
Thanks. So my life is over now.
Sir, we'll let the officers know you've completed your arraignment. Thank you.
No, sir.
Yeah, my life is pretty much over, man.
His life is over, guys. His whole life is over because he's getting extradited.
Ready, Ms. Henderson?
He's getting extradited back to the state where he committed crimes to face those crimes because he can't get into mental health treatment right now, right this second. Not yesterday, not 2 weeks ago. It was fine then. He needs it right now or his whole life is over. This next guy, I got this clip not because anything bad happens, but because of what he was charged with. It's crazy. The whole thing is crazy. It is. The lawyers do a good job fighting for this guy, but wait till you hear how drunk he was.
All right, file in hand. I'm ready. Your motion.
Yes, Your Honor, this is our motion. In this case, as indicated, based on the police report in the video, we filed this motion to suppress blood test results. Your Honor, Mr. DeBone was found sleeping in his vehicle in a parking lot, a vacant parking lot. And the officers tried to wake him up at the parking lot. And he was, they did an affidavit for search warrant, and obviously with respect to the search warrant, do you mind if I go to the?
No, that's fine.
It's just easier for me.
Yeah, Heather will pick you up either way.
Thank you so much. So, so they submitted the affidavit in support of the warrant, and the, the only thing that they indicated, I believe, in the warrant was that, he was sitting in the driver's seat. Nobody observed him drive the vehicle. And there was an odor of intoxication from his breath in the interior of the vehicle. And really, no other information was given for the affidavit for the search warrant.
Let me cut you off. Let's assume just for a second, let's just assume that there wasn't enough information in the affidavit.
Yes.
Then that gets us to counsel's, I'll call it backup argument, that the exclusionary rule says the officer was acting in good faith on the search warrant. So what the result you're asking for, which is to exclude the results, isn't appropriate anyhow. Let's talk about that argument.
Yeah, Your Honor, the our position is that you have to have probable cause, just like you have to have for an arrest, you have to have probable cause for the search warrant. Even if the officer's acting in good faith, there has to be, as the Supreme Court's determined that the getting a blood test is, you have an expectation of privacy regarding your, having your blood drawn from your body.
I understand, but isn't that what the good faith exception is all about? Is, good faith meaning the officer didn't do anything in bad faith, but the officer submits his paperwork, magistrate screws up. Let's just assume that the magistrate that issued the warrants, signed the warrant, screwed up. Yes. But the officer is acting in good faith, saying, I did everything procedurally I was supposed to do. I submitted my affidavit. The magistrate signed it. I've got a search warrant. I go to the hospital. I'm acting on that search warrant. Ultimately, if it's found out or it's determined after review that the magistrate did screw up, isn't that what the good faith exception is all about? Is the officer still protected by his good faith? I think it was a he. His good faith actions based on that search warrant? Isn't that what the whole good faith exception is about?
Yeah, I just think in this case, Your Honor, that in order to have the blood test, so there's no timeline in this case that would show when the driver was driving, correct? Because there's no interview. So there's no way you can proceed forward on the case because there is a scenario where the individual could have been, consuming the alcohol in the vacant parking lot. Sure. And so you still have to have probable cause to proceed with the case. And there is no timeline to establish when.
And I don't mean to cut you off, it's just the way my head works.
Yeah.
But doesn't all that go to the weight of the evidence?
No.
You can certainly argue that at trial.
I think
they've got a blood alcohol result that's X. I don't remember what
it's high.
Was. But, it's X. Let's just say it's 10 because we know that's overly low. It's 10, but they've got absolutely no evidence to present to the trier of fact about when the alcohol was consumed.
No, as a matter of law, they have to have probable cause to arrest him, and they arrested him and took him to the hospital. So in order to do the arrest, you have to have at least probable cause. And so
so you're getting off of your search warrant argument now. You're just talking about probable cause for the arrest.
Right.
Go ahead.
So, they have to have probable cause. The So there's no timeline established as to when he consumed any of the alcohol. He could have been there for 5 hours. He could have been there for 10 hours. The parking lot's vacant. There's no one else there. There's no field sobriety test. There's no PBT, obviously, because they were unable to do it because of his position. And his vehicle wasn't in a place where, there were other vehicles. There's no other vehicles. There's no other people. So it's a completely vacant parking lot, Your Honor. So you still have to establish as a bare minimum probable cause to arrest. And so if the blood test results are the blood test results, I still think they're suppressible, Your Honor. But even if they're not suppressible, for them to arrest him, they have to show a scintilla of, they have to show some probable cause, which is a low level, I understand, the burden of proof, that he was operating while intoxicated. It's a conjunctive. It's not separate. Right. So they have to show, and they'll be unable to show based on the report in the video that I viewed, and I think the prosecutor viewed as well. I think they're going to be unable to show that that there's probable cause to arrest. So if there's probable cause to arrest, that there's an issue where the case should be dismissed. Okay. Even if the blood test comes in allegedly under the good faith exception, because the officer, I would think, would know that just the odor of intoxication is not enough for him to get a blood draw, because I believe there's even a case law on point, and I don't have it at my disposal at this moment, but I think there's a case that says odor of intoxication alone is not enough for probable cause for the blood warrant or the blood test, nor even if we're observing him driving. And so there's no testimony that's going to come in that's going to say he was driving at this point in time. There's none, from what I gather, based on the police report and based on the video. And it just falls into one of those. This is a unique case. This type of case doesn't happen very often. True. And so when it happens, you got to kind of look at, usually what happens is, in order to save the probable cause, what they do is the officers, which is a good idea, is they get information from the client to establish the timeline so that you have at least a timeline as to when he consumed the alcohol. Here, there's absolutely zero timeline. And, so that's the issue. And there's no reference about anybody, even an anonymous witness, seeing him operate the vehicle. Right. Okay. So, all right. Thank you, prosecutor. You can stay there, come up, doesn't matter. That's fine.
I guess we'll start with probable cause since we're kind of backtracking a little bit. Defense apparently, as often happens, I feel like a broken record, has watched a very different video than I have. There certainly was probable cause for this arrest. Defense is wrong in that People v. Rizzo states there is enough probable cause to arrest an individual based on the odor of intoxicants. In this case, there is that. There's also the individual was parked haphazardly in the parking lot. It wasn't like he was in a spot or something. It was a business that had had previously been open, now closed. It was 2 a.m. So I understand his timeline argument, but that's not necessary really. But we also know that he wasn't there during the open of business. It's a golf course in August. I'm sure it was busy. But also, so the vehicle was running. The vehicle was in drive. The officers did have to put the vehicle in park and take the keys out, or turn off the vehicle or what have you. So the operating while intoxicated certainly is there for a probable cause standard at the very least. Defense seems to minimize how unresponsive the defendant was at the time of the arrest or throughout the entire investigation. For example, the police and fire both attempted to wake defendant up for 20 minutes. They tapped on the windshield, they tapped on the top of the car, they shook the vehicle, they yelled at him, they did all these things to try to wake him up for 20 minutes. Knowing that he wasn't going to come to, they broke the front window. It was laminated, so they couldn't get through, so they had to break another window. That didn't even wake defendant up. They lifted him out of the vehicle onto a stretcher. He was still unresponsive. They put him into the ambulance. He was still unresponsive. He couldn't answer simple questions like what his name was or what he was doing. It would be ridiculous to expect an individual who is that unresponsive to do anything like being interviewed by police because he was unable to be. He couldn't do field sobrieties. He couldn't take a PBT. He couldn't do any of those things. And that is specifically why a blood search warrant was sought. So the search warrant for blood contains sufficient information for the purpose of determining that there was a fair probability that defendant's blood contained evidence to determine that he had been operating while intoxicated. The affidavit for search warrant completed by Officer Sasai clearly shows at the time the suspect was under arrest that he observed the suspect sitting in the driver's seat of his motor vehicle and that the suspect had an odor of intoxicants coming from his mouth. I understand that the defendant seems to take issue with the fact that the search warrant doesn't contain any of those additional pieces of evidence that I've already discussed, but it does very clearly state that the suspect was not responsive, and that's why they're seeking that search warrant. So those pieces of evidence, like how he did on field sobrieties or whether he admitted to consuming alcohol, isn't in there because he was non-responsive. And even if this court, for whatever reason, were to determine that there wasn't enough probable cause or sufficient information to determine probable cause in the search warrant, like I said, there is a good faith exception to the exclusionary rule, and that is applicable here, and suppression of the 0.367 blood results is not a
0.367. 0.367. How in God's name? Now, I drink a lot. Throughout my life, I've drank a lot of alcohol. I've never... 0.367? How in God's name? And then he drove? Like, he had to have drove. Let's get that out of the way, because there's no one else in the car with him. And the car's parked in this part, not parked, just in drive still. And he's in the driver's seat and it's running. His friends would have had to drive the car there with another car and pick him up and place him into the driver's seat and put it in drive or what. No, he was driving. Man, that is high.
Your term, Mr. Bahana.
Yeah, Your Honor, obviously the police officers didn't know the results of the blood test, and that's what we're supposed to be looking at, what the officer knew at the time of the arrest. And so he was unresponsive. I think I acknowledge he was unresponsive. He couldn't do the field sobriety test. We're not, I understand that.
I got you.
He was passed out in the vehicle. And so my only point was that usually you need some kind of timeline to establish that the vehicle was, moving, and that he had been under the influence at the time it was, doing that. So that's my point.
Okay,
that's all.
All right. Thank you both. I don't get enough fun like this, so I appreciate when I get two attorneys that know what they're doing and can argue things. I think the case law is pretty clear. A running vehicle in drive in a place open to the public is enough probable cause for the arrest. And although I'd certainly like to see more in the affidavit, I think the good faith exception protects the officer that goes forward based on that search warrant. So I'm going to deny the motion. Anything else we can accomplish today?
We can still try to pre-try, Your Honor.
That's fine. That's fine. We got lots of space for you.
Nothing else happened. They went on to another case. He said we could still try to pre-try, so I thought they were going to move on. He went to another case. These two lawyers came back later and continued it. So nothing else happened. But my goodness, they were both really good attorneys. They were, when the first guy was talking, I thought, yeah, that's horrible. How can you arrest someone when you never even saw them driving a car? You can't arrest someone. Yeah, you can. Guys, let's go to Florida because it's always fun going to Florida. We're going to go to Florida. Here we go. That's his chains.
0513, 0514, and 05279. I did attempt to speak with him this morning. I think he was a bit frustrated, and I'm going to kind of let him decide what we do today.
Okay. Sorry, tell me the
Jeremy Gafford.
Okay, got it.
Number, and when I look, number 15 on my docket.
Correct. So where are we at?
Sir, with all due respect, I'd like to address the court and the state on my behalf.
Say what? So we're here on a violation of probation. He's entered a plea previously. This is the first one.
Yeah,
this is the fourth one.
Yeah, Sean.
This is the fourth court date. Okay. I would just like to say this, please.
Hold on. Raise your right hand. You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
So help me God.
And you understand that this is being recorded, and as you hear on TV, anything you say can and will be used against you in a court of law. Do you understand all that?
Yes, sir.
Okay, and you're doing this anyway.
On my own free will.
Fire away.
Okay, sir. 20 years ago, I was sentenced to 20 years in prison mandatory. I served that sentence 240 months. I was released on May 10th. I was released homeless, no family, no friends, nowhere to go. They let me out on Highway 98 at the Shell station. Okay, I didn't know what to do. I didn't even know how to work a phone. Throughout all that, I got myself off the streets, found a place to stay. I had 3 different jobs. My only fault was I was doing drugs. And the only reason I did that, I've never even did drugs before. I was just the people that I was around. I'm in here right now for a dirty urn.
Okay, stop right there. Guy, you're talking to the judge. This is what you're telling him? This guy is great.
I have my life together. I have everything. I don't want to be a criminal no more. I spent 20 years of my life in jail, in prison. I'm not a bad, okay, my past is my past. I don't have no, I just want a chance. I don't feel like I had the opportunity.
What are you asking?
I'm asking, this is my 4th court date. My lawyer's been telling me for the past 3 months, if I could find a drug program to accept me, then that the state would be on board. Okay, I found the drug program. I did the interview. They told me if you can get the judge to agree to this, we will come pick you up today. When I see my judge, now the whole story's changed. He says that the state told him he agrees to it, but his boss man is saying prison. I don't understand. I mean, for 3 months now, he's been telling me to find this program. I found the program. The people said they will come get me today. That's all I need is just a little help to not be homeless and not struggling. You know, I don't even know how to work the phone when I got out of prison. Okay, I'm sorry, but please give me one opportunity. If I will take a reinstatement on 15 years probation with a 6.5-year suspended sentence. I just want a chance. I mean, I have somebody now.
What's the state's position?
Judge, I'm not privy to the conversations that the defendant has had with his attorney. What I will say is the conversations that I've had with the defense attorney are this. He scores a substantial amount of prison time because he was in jail on 3 robberies with a firearm.
20, no firearm. No firearm.
3 robberies with a weapon.
20 years ago, and I served that.
Let him say it.
He scores a substantial amount of prison time. Now, he violated earlier this year, and we gave him a shot by putting him on community control. He violated a second time. When Mr. Gates and I saw this case come up, I said, if you can find a program, I'll listen to what you have to say and hear you out. I was very non-committal. I didn't say that I would agree to it. I brought that to, they got him into a program. I brought that to my supervisor, and the state's position is that it's not appropriate given the circumstances. So that's where we're at. I at no point ever said that the state would give him a treatment offer in the circumstance. Mr. Gates got him qualified for a program, I believe. I think Mr. Gates can talk to that. The state understood that. The state considered that. The state decided that that's not appropriate here, especially given the fact that we put him back on community control, which there's not much else we can do at this point.
Okay, now, once again, when y'all let me out of prison, y'all let me out homeless. I got a dirty urine and came to jail. You let me out on community control, homeless again. And when I went to the community control, the lady was like, well, do you have an address to give me? She says, you know, you got to stay at home. And I mean, all I could say was, I'm homeless. I'm always at home. You know, I don't know. I just don't know what to do. And I feel, and my past is being held against me. These people told me that they will let me come stay there, take the drug programs, take the classes, help me get a job, help me get my medication, everything worked out. I need this opportunity. Prison is not the place for me. I can't make it in there. Let me look at me. Just look at my head. Look at me. It's prison. It's been rough on me. I don't want to live. I don't want to be that person anymore. I don't want to be in that mentality. I'm begging you, just please give me one chance. If I go out there and mess this up, then by all means, I'll sign anything saying if I go and violate and come back, then there won't be, I'll take the 11 years. I'll take it. I'll sign right for it. I'll agree to that right here on camera where everybody can see it. Just give me a chance.
Okay, I hear what you're saying. So, you want to add anything, Mr. Gates?
Your Honor, and just to clarify, the conversations were never the state would do it.
I understand what the situation is between them.
And just so the record's clear, the state, I always said the state was open to it. They're willing to listen to it.
And that's what the state just said.
And even today, it was the same, that they were open and listened. Unfortunately, the state's position was no. I told Mr. Gaffer the options were potential evidentiary hearing or sentencing, but that would be put off. And I know Mr. Gaffer is frustrated by the time it's taken to get it resolved, and I don't know that he really wants to delay again for a potential resolution. And my concern, obviously, is this court hasn't done a lot of plea and sentence immediately, and so that was the concern I had with Mr. Gaffer. And so that's where I left it. He voiced his frustration. I said, I'll let you come out and you can address the court. I'll go wherever the court wants me to go.
It's been 4 months. I just want a chance.
No, I got it. I hear it.
I don't know what else to do.
Okay, so here's the deal. First of all, I don't get in the middle of negotiations.
Yes, sir.
The state, basically, what you just heard is that your state attorney took it to his boss. Boss is the one who nixed it. Now, I'm not saying he would have gone along with it, but certainly that's not what happened. He can't control that. It doesn't matter. They're not even here. We can't deal with that. And, you know, as much as you want to do something, I can't force the state to accept that. The one thing that you can do, you want to make these arguments. There's only one content. I'm not suggesting you do this. And I'm certainly not promising you anything. But if you want to basically admit the violations of probation, you can go to a sentence that you can argue all you want to me, and I'll make a call. I'll make a decision. You can make your arguments. I may, I don't know, send you down the road for 10. I don't know what's the guidelines, minimum guidelines for this.
I can pull it, Judge. Give me one moment.
And just so this is all VOP, so guidelines, while they are the minimum, aren't actually controlling. We don't need a downward depart. The court could always modify and reinstate.
Gotcha. That's important to know.
I had bottom in at 132 months,
Okay.
Which was roughly a little bit more than 10 years.
I have that as well. It's 132.38 months.
So hey, I understand why you're upset. You're looking at another. You've been in for 20, and you're looking at another 10. That's great. I understand why you're upset, and making matters worse, dragging it out and making you do so. That's your call whether you want to try and do that. And I don't know exactly when the sentencing would be. If you want to go that route and argue with, if you're unwilling to accept any offer, the state has to, and it's not even me, the state has to, not the state, but if you're doing a straight up admission, then nobody can object to that, right, counsel?
No, Your Honor. And I think part of Mr. Greber's other frustration is he had 4 cases in 2005. He was sentenced to essentially 20 years in one case, no DOC in the other 3 cases, with 15 years of probation on that. So essentially he served all the time in one case, and he's got no credit at all, except for maybe 5 or 6 months on these other cases. So to be looking at additional, 10 years incarceration on that, as I told him in probation, and I talked about this, we feel like we kind of let him down on the way out of DOC. I wish we could have done more for him. I've explained, either way, I'm good with an evidentiary hearing if that's what he
I'll
wants.
tell you straight up that often happens, and people that are actively involved in the system. I'm not saying I'm happy about it. You get dumped on the street after that. It's like people don't realize when you dump somebody out on the street. Hey, guess what? You're a member of our community. We all suffer when something bad happens to you, and or you do something bad. We all suffer. A lot of people don't realize that. It's not like you and I. It's not like us against them. It ain't like that. It's about we. It's about a community. We have a vested interest in you being in the community and being straight. Anyway. So, next. So this is our last miscellaneous of this year, right? Do we have one next week?
We have one on the 19th, Your Honor.
What do we have on? I'm not going to get myself in trouble if I don't think we really, if you choose to go that route, I'm not pushing you to do it. We can accept the plea today, but I can't promise you when we're going to do the sentencing. That may be a month or, as a matter of fact, I suspect it would.
Judge, may I make a suggestion?
Sure.
We do have our trial cycle coming up, but there are several days in the trial cycle at the end of December that I don't think anything's actually going to go to trial. We could do the sentencing hearing on that day.
I'm not available, as I explained to the...
No. I appreciate your
and what I'm just as I said, hearing, sentencing, I've done as much as I can. I've talked with everyone, I know what we need to argue at either. So I'm not concerned with that. I just need Mr. Gafford to decide what he wants.
Yep.
And I will make it a priority to get him back in as soon as I can for either one.
So why don't we do this? Why don't we, we've got a few more, we've got some cases. Why don't you guys talk about it and bring him back this afternoon and try and figure out what he wants to do.
Your Honor, after talking with Mr. Gafford, it sounds like he'd prefer just to have a hearing because there is the positive, but there were some other allegations, I think, at this point. Obviously, if we change between now...
You want evidentiary hearing?
Yes, Your Honor. And obviously, if that changes between now and then, I'll let the court know. And if we've got it noticed, we can always turn that into a sentencing if we need to.
So if we do want to say you need to...
Yes, Your Honor.
You need to call Ms. Riley and get it.
And I will do my best.
Try to add a couple of days.
I will do my best.
Won't be between now and the end of the year, but
I'm a little confused about
days.
something though. I just want to ask the state, so the drug program, that's not an option?
From there, no. From there, maybe. He can't promise you, but that's the only option.
Is there any way if I plead to this and go to sentencing that we can cap it? I just don't feel like a dirty urine. It should be punished.
Negotiate whatever you want.
And
you want to negotiate a cap, that's fine. But the one thing The one thing I was saying to you is that you have the authority to enter an admission and argue all these things the same, but that throws the discretion. If you want to have something set, that's got to be based on a deal between you and he's talking. So you got a very
Will it take 11 years suspended sentence and then take it back on 15 probation?
No, sir.
No? Is there anything
Okay.
that you're
No,
willing to do?
don't negotiate directly with me. Your attorney, believe me, very good negotiator.
So it's either here
And
or
he's going to get you the best deal. He's got deals that he means surprised me.
Mr. Gafford has expressed his desire for a hearing at this point.
Very good, let's do it. So we'll
I'll
go ahead and schedule it.
Yes, Your
Schedule
Honor.
a hearing.
I don't know. It sounds like that judge is on his side. Like, yeah, we dropped the ball when we dropped you in the middle of nowhere after you got out of jail. I mean, he did have 20 years to plan on what he was going to do when he got out of jail. But, he felt bad that, he was homeless. And yeah, I can see how he would be homeless. There's no way he could get a home while he's in jail. But he started doing drugs. I mean, if he didn't want to go to jail, if he didn't want to go back to prison, not jail. If he didn't want to go back to prison, then he wasn't a drug addict before he went into prison. I mean, that just was something he decided to do. I don't get it. I don't understand. The judges, I don't think this judge is going to give him 10 more years. I just don't. So we'll see. I'll try to get that one. Some of them, I don't care. Like the last guy, the drunk guy. I'm not going to try to get his sentencing. I don't care. I know that he was definitely guilty, and I'm pretty sure the judge is going to convict him. But this guy, I'd like to know what happens to him. I might get him. I might not get him. Now this next one, it's not the best audio in the world. It's 10 minutes long, so you can fast forward it if the audio annoys you. But it's the end. The end is the best part.
All right, I have John Major and Josh Cooper is here, and Glenn Gibson is back on the video. And Mr. Major, Glenn is alleging that he's paid all of his fines and he's done all of his community service.
We do not have record of that, Your Honor. As far as money, we show that he paid 12/6/2010 $25, 7/11/11 $300. He was sentenced in the OVI case to $1,000 fine. On the A case, $150 on the B case. So that right there is more than what he's paid. We'd have no record of any other payments. He was also, as far as community service, we have record of 30 hours of community service done here at the court and at the Chesapeake Community Center for 30 hours. He was ordered on the OVI case to 90 hours of community service on the OVI. On the A case, 60 hours of community service on the B case, just for the OVI.
Okay, how much does he owe in community service?
On the top of my head, I did not get that, Your Honor, but it's looking like there's 150 on the OVI that he owes, still owes.
150
hours of community service on the OVI and 60 hours of community service on the criminal case, the A case. And he's only done 30 hours of that. That's what it was applied to, was the criminal A case.
So we're down to 30 on that one, right?
Yes, that is correct, Your Honor.
So it's 150 plus 30.
30 hours, that's right.
So a total of $180.
That is what my house told me.
And
Hours of community
right,
service.
tell me about the fines and costs again. Give me a total.
Oh, I don't have a total, Your Honor. There should, the one in the file, there should be the,
Here.
This is Chesapeake, Ohio, Jim.
$1,875. Well, it appears to me, Your Honor. $1,875. And he's paid $325 on it. That should be already in that total of what he paid.
Oh, so the 1875 is the balance?
Is the balance, yes, Your Honor.
Okay. Mr. Gibson, I hope you could hear what John was saying, but he says you owe 180 hours of community service and $1,875 in fines and costs. Now, do you dispute that?
Yes, Your Honor, and the only way I can check it is I'd have to go get a hold of the bank and go back and get the bank records. That's, like you said, that was what, 13 years ago?
Okay. How much jail time does he have suspended?
On the OVI, the A case was 17 days suspended. The B case was 15 days suspended. On the criminal case, A case, there was 90 days suspended. And on the B case, there was 90 days suspended. And with giving him credit for what time I know of, leaves him 210 days of jail time suspended.
I come up with 212.
He had, yes, but he had 2 days of jail time that he was given back in 2011 that I credited him for.
Well, I hear two totally different stories. I hear our probation department saying that he hasn't paid $1,875, and I hear the community service department saying that he owes 180 hours, and I also hear from the probation department that he owes 212 days.
210 days, Your Honor.
213?
210.
Oh, sorry. I'm sorry.
Is what the balance is.
210. So, I've had so many cases today, I don't remember if I asked you, are you employed? Do you work?
Yes, Your Honor, I work at A1 totally.
And how much do you make?
I take home $678
Right,
a week.
yeah, I remember that total's 35,000 or something like that. Okay, you make too much for a court-appointed lawyer. And where do you live now?
Over in Barbersville.
Okay, well, if John is wrong, it'll be the first time I've ever seen this on a massive scale like this. Now, John may have been wrong on a day or a few dollars, but not on 210 days of jail time, 1875 on fines and costs that you say you paid and 180 hours community service that Josh says you haven't done. And Josh would know you like a brother if you had done 180 hours because you'd be his best friend. So you know what I'm going to do? I'm going to.
Your Honor, he had me, I did those over in West Virginia and mailed them in to him.
Yeah.
And I'm not saying that the jail department had a problem or anything, but being in jail, I can't find anything out, I can't do anything, so.
Yeah, I know.
I'm just at the mercy of the court right here, right now.
Well, I'm going to give you some time. Today's the 15th. I'm going to give you till December 18th, that's Monday. You need to get a hold of somebody and have them round up this evidence December 18th at 10 o'clock.
Your Honor, not to interrupt you, but I'm single, by myself, and I have nobody that can round that up, nobody.
Okay, here's what John has already told me what he would offer you, and you're not going to like it. He would offer to clear the case out if you spend 210 days in jail.
That's correct, and I did a recommendation to the probation department.
So,
Your Honor, I did that.
You've been going, listen to me a minute. You said you didn't want to interrupt, so please don't.
All right.
You've been going for 13 years, and we haven't seen you in 13 years. Now, if what you're saying is true, it would be the biggest mistake the probation department's ever made. And before you get 270 days in jail, I want Judge Capper to make that decision. Okay. So I'm setting it for 12/18/23 at 10 o'clock in the morning, and that's next Monday. And Judge Capper will decide how to deal with your situation. And you basically, the record says you've ignored us for 13 years. So your best shot in this is Judge Donald R. Capper.
Now we'll hear what the judge really thinks.
Yes.
So, Your Honor, you're keeping me in jail?
Yes. Basically, I don't believe you.
State of Ohio versus David Woodard Jr.
They should say that more often. Judges should just say that last line. Mic drop more often. I don't believe you. I just don't believe you. I mean, I don't believe him either. All right, I got one more video. Now, I try to show you guys, real good judges that are on point, judges that handle these people really great. This is way different. This judge is the most unique judge. I owe a huge apology to any judge that I called a kindergarten judge before. Even that one lady in Washington with the long curly hair that's also a defense attorney sometimes. What's her name? It doesn't matter. Doesn't matter what her name is. She has gray hair. I call her a kindergarten judge, and I apologize to her for calling her that because she's not. Here we go. This is a kindergarten judge, and this is going to infuriate you. When you hear this judge talk, you're going to get mad for no reason. There's no reason to get mad, guys. Just calm down. What you're going to, because I did. If someone spoke to me like this, I would, I don't know how I would react.
Hi. We are here today for an arraignment, and this is the matter of People versus Kayla Elaine Moore. This is case 23-0552-OM. May I have appearances for the record, please?
Thank you, Your Honor. Jonathan Foreman, Office of the Public Defender, here with Ms. Moore, who's appearing from the East Lansing Police Department lockup. We waive any in-person appearances today.
Okay, thank you. And Ms. Moore, could you state your name for the record, please?
Kayla Moore.
Thank you. And I can see and hear you clearly. Can you see and hear me clearly?
Yes, ma'am.
Okay, thank you. So this is the time and date set for an arraignment. And at an arraignment, well, I call arraignments the worst case scenario hearing. And here's why. I'm going to read the charges against you with the maximum possible penalty, and you aren't going to get a chance to say anything. There's a reason for that, okay? You are innocent in the eyes of the law, and the court is not going to let you say anything that might come back to haunt you later. And Mr. Foreman, I promise you, is certainly not going to let you say anything that could come back to haunt you later, okay?
Yes.
But although you're innocent, you are accused of a crime that could put you in jail or cost you fines. You have a right to know what those charges are. You can't really defend yourself unless you know what you're accused of. So that's why we have an arraignment. So you will know the charges against you, okay?
Yes, ma'am.
All right. Okay. The most important thing I can tell you this afternoon is that you are innocent in the eyes of the law. You are innocent and you remain innocent unless, not until, unless you plead guilty or found guilty beyond a reasonable doubt at a trial. And I say unless because it's different than until. Until is something that's going to happen sooner or later. It's just a matter of time. Right? Unless means we don't know if it's going to happen. And in this case, we don't know what's going to happen. You haven't seen the evidence. Mr. Foreman hasn't seen the evidence. Court hasn't seen the evidence. So you remain innocent unless you plead guilty or are found guilty beyond a reasonable doubt at a trial. Okay. That said, the charge against you is destruction of property, and in count 1, you are alleged to have willfully destroyed or damaged or in any manner defaced, destroyed, injured any property not your own by scratching and keying the victim's vehicles at approximately 8:35 p.m. on October 3rd, 2022 at 326 Mack Avenue, East Lansing, violation of the city ordinance 26-231. So this is alleged against the peace and dignity. This carries up to 90 days in jail and or up to $500 in fines. And this is alleged against the peace and dignity of the people of the state of Michigan. You have certain rights. You have the right to an attorney. And today you're represented by Mr. Foreman from the Public Defender's Office. Mr. Foreman, will Ms. Moore be applying to your office for representation?
Yes, Your Honor.
Okay. So if you can't afford an attorney, the court will provide one for you. And I am especially proud of the superb public defenders we have in this court. Okay? You have another right. You have a right, as this case goes forward, to go to trial. And at that trial, the prosecutor would have to bring evidence against you. You could question that evidence. You could bring evidence, or you could just sit there, because it's the prosecutor's job to prove guilt beyond a reasonable doubt. Okay? If you had a trial, you would have the right to testify on your own behalf or remain silent. And if you remain silent, no one could use that silence against you. They couldn't be like, oh, Ms. Moore didn't have much to say there. No, you have a right to remain silent. At this point, Mr. Foreman, do you believe Ms. Moore has an understanding of her rights?
Yes, Your Honor.
Okay, thank you. And how will Ms. Moore be pleading this afternoon?
Not guilty.
Thank you. And the court accepts that plea.
I would have loved him to say no.
So we're
she
going to
doesn't
talk about some
understand. Try
dates
again.
for you to come back to court, Ms. Moore. You will receive these before you leave lockup. So you'll receive these in writing.
Jim, yes.
But we still read them into the record. So you will return to court at 1:45 p.m. on January 11th for a pretrial conference, at 2 p.m. February 12th for a final pretrial conference, and 1 p.m. February 13th for jury selection. Now, I want you to stay in touch with your attorney, because some of these you'll have to be in the courthouse for. Some you might be able to appear by Zoom. Some you might not have to appear at all. Okay? So stay in touch with your attorney. Mr. Foreman, would you like to be heard on bond or bail?
Yes, just briefly, Your Honor. I'll note that while this is an old case and Ms. Moore failed to appear for arraignment, she has since moved. Since the allegations here were apparently from last October. The charging document wasn't signed and wasn't sought until September of this year, it looks like. And she had since moved. I provided an updated address to Ms. Lewis, but I think that explains why there was a failure to appear for the arraignment here. Ms. Moore, it's my understanding, is a lifelong resident of Lansing. She currently lives with her dad. She works in Lansing. She works as a nanny. It's my understanding that she has no prior criminal history except maybe some traffic things, but nothing related to this as far as is my understanding. So given her ties to the community and her relative lack of a criminal history, Your Honor, we would request a personal bond this afternoon.
Okay, thank you. Let me just...
Just so you know, this is not Washington. Washington does this in their courts. They take forever. This is Michigan. This is Michigan, Lansing, Michigan. Right, yeah. Right, or am I wrong there? Jim?
All right, I am going to order a personal recognizance bond, but as I said, so that means, Ms. Moore, you don't have to post any money with the court today. However, because we talk about worst case scenarios, particularly in this hearing, if for some reason you don't appear in court in the future, I have no reason to doubt your word, but if for some reason you don't appear in court in the future, there will be a bench warrant issued for your arrest, and then you will have to pay $500 to get out. So it's what we call a PR $500 bond. Okay? I'm going to put some other conditions on your release, and you're going to get these in writing before you leave the lockup, but I'm going to read them to you now. Okay? Doesn't necessarily mean I believe you're going to do these things. I always feel especially bad about number 2. But in courts, we deal in worst case scenarios. So here goes. Number 1, you are not to leave the state of Michigan without prior permission of this court. Okay, now if you're going to leave, we have a form on our website that you can submit. I can't make any promises, but I've signed every one of them so far. But you need to fill out the form before you leave. That's the important part. You may not commit any crime while released. Again, I have no reason to believe you will, but we tell you up front. All right. You must immediately notify this court in writing of any change of address or telephone number. Now, because I was a public defender, I got ghosted about every 7 minutes. You must also tell your attorney about any change of address or telephone number, okay? You may not use alcohol, recreational marijuana, or any illegal controlled substance. If you have any medications or prescriptions, you are to take all medication as prescribed. Do you have a medical marijuana card?
No, ma'am.
So you may not use marijuana at all, and you may not apply for a medical marijuana card while this case is pending, okay? You may not possess or purchase a firearm or other dangerous weapon. You may not use any object as a weapon. You may not engage in any harassing, intimidating, violent, or stalking behavior toward anyone. Okay. You specifically may not have contact with Elizabeth Robinson, Chloe Michelson, or Tina Vitale. You may also not have contact with Shay Lynn Diederich, who was a co-defendant. You can't have any third party contact them. Okay. You can't have any intermediaries, no messages through social media, no vague booking, as they called it back in my day, or direct Facebooking or any other kind of contact.
No, they didn't. Vague booking back in her day.
At this point, I don't know if the victims still reside there, but you may not go to 326 Mack Avenue in East Lansing, 48823. I'm not going to ask. I'm going to state this out there, and then you can converse with Mr. Foreman afterwards if you have concerns. You may not operate a motor vehicle unless you have a valid license, proof of insurance, and all registration is up to date. Okay? We have, I know it doesn't seem directly related to this, Mr. Foreman, but we have 6 violations and 2 suspensions, at least, in the past 6 years. So, actually, we have 7 violations. So just be sure that is all up to date and buttoned down before you drive. And if you have any questions, or if Mr. Foreman has any, Mr. Foreman, do you have any questions?
I think, Your Honor, that the purposes of, and I'm looking through the court rule as we speak right now, but I think that those conditions would not be reasonably necessary to ensure that her appearance is required, or that she appears in court, or for the general safety of the public as it relates to the allegations in this matter.
Okay, keep your hats on, because he literally just said for her to put a condition down saying don't break the law, that's not appropriate. And this kindergarten judge is going to handle it. She will handle her business.
So I don't see how I don't believe that that those conditions that have been laid out relate to the charge here. Of course, there are some of them, as in she can't drive without a valid license, it falls under that she can't commit a crime while released. But as to why there's a specific condition, I'm not sure that it relates, especially if it were to be entered in lien or anything. I'm not sure that relates to the specific charge here. And thus, I don't think it would be an appropriate condition of bond.
Well, each of these are actually required by law, but in case there's any question, so it is not legal to operate a car without insurance. It's not legal to operate a car without a valid license or any motor vehicle. And the interest of public safety, it's just a concerning record. So you can always make a bond motion, but I think actually they're already covered, as you astutely noted, by may not violate any laws. Okay. Anything further for this record?
Just, Your Honor, just briefly, this isn't related to Ms. Moore specifically, and it's actually not related to the court's ruling here today either, or the bond. But I have noticed, I think recently, an uptick in these general types of cases where there are cases, 90-day misdemeanor cases issued by the city attorney, where there was a significant lapse between charging, or between the alleged incident and the charging, and it just, in a situation like Ms. Moore, where she has moved since then, just caused a significant disruption in her life when she's eventually picked up, all without knowing that a warrant was out for her arrest. This is a case where she has a presumption to have an appearance by Zoom or in person for that arraignment, but the lapse in time, the delay in time, destroys that presumption because things happen in that year. So things and then person gets arrested, they're lifted out of their everyday life, their car could get towed, things like that. And it's nothing related to Miss Moore specifically. It's just something I want to alert for the court, because it is something I've noticed an uptick in recently, it feels like.
Don't go to Georgia
I've
then.
noticed those from both the city attorney and the county prosecutor throughout my tenure. And it looked like we started picking up a lot of them summer through now. Actually, I haven't seen many of these as recently. And I agree. While you were speaking, I also, I'm going to cancel the warrant fees.
Thank you, Judge.
Because the money was, the warrant notice was sent to the wrong address. And I'm not saying this to be snarky. This is one of the reasons why updating your driver's license is important, because that's the license the court uses to try to reach you. And I know there may be many factors, but that's one of the reasons. Or if for some reason a driver's license is not happening in someone's life right now for any number of reasons, perhaps a medical condition where you can't drive, or etc., get a state ID that kind of looks like a driver's license issued by the Secretary of State, because there is nothing worse than the court having tried to reach someone, then entered a warrant thinking that the person is blatantly ignoring them, only to find out that someone didn't know and has been picked up. I mean, the court does not like that at all.
She was ignoring you.
And no one likes that.
Understood, Judge.
Right now, the only mechanism the court has to reach someone is using the address that's on file with the Secretary of State, unless someone contacts the court to ask us. And if someone doesn't know or doesn't expect to be charged, then they don't do that, which makes problems worse. So, and I don't say that about the driver's license to be snarky. It's just, that's the only mechanism we have. I am, however, while we're speaking, and the proper word is strike. I would use the word strike, but I don't think that's a proper legal term.
I think it accomplishes the goal, Your Honor. Thank you.
Okay, so we're going to strike all the warrant fees. And then we'll go to the PR $500 bond. Okay.
Thank you, Judge.
Okay, thank you. So, Ms. Moore, I know that you are a grown adult and have seen some of life. To me, I have socks older than you. So, in this court, we see a lot of young people for one bad experience once in their lives. And that is my hope for you. Okay. It looks like your case will be coming back before me. The other piece of advice, most important piece of advice I can give you, when you have any questions, ask your attorney. Okay. Courts are kind of like the Catholic Church. We have our rituals. We do things the same way. And we think everybody does things that way. Or we use certain phrases. They mean something in the court. They might not mean something to you, or you might have heard it slightly differently from a different court. Always ask your attorney. Ask your attorney what's going to happen at a particular hearing. What does this mean? What are my rights? That is the best way you can help your attorney represent you. Okay? So,
Thank you.
You're very welcome. And again, I don't know how this is going to play out, but I do hope there is a time in your life where you never have to see me again. Okay?
That makes us both.
All right.
I was going to say,
No.
Did you see what they just did? They acted like the inmate started unbuttoning her shirt slowly. Like, no, stop, don't. They both just lost their minds because she said some words. She's going to go home to her husband and be like, had a rough day in court today. She tried to talk. You don't know how bad it was.
Let's not right now, okay?
It's not that I don't care. I do care. Again, I just don't want you to say anything that might come back to haunt you later. So I can let you speak to Mr. Foreman when I'm not here, but sometimes the best intended things can backfire, and I don't want that to happen. Okay? So that is all for this record.
I can't guarantee, but I'm going to do my best never to push that judge on us ever again. I had to show it once because it was just, if I'm going to sit in misery to get content, then you guys have to sit in misery with me. So we did. And we made it to the end. My Lord. Yeah, we would all have to, I don't know, edible and then her or something. I don't know. But that's all I got for tonight. It's been an hour and a half, so I want to do more, but I think I should end it. Yeah, that was great, guys. Thanks for coming out. I hope your life isn't over. Listen, just some advice. If you need mental health, get it now, because if you get arrested, they're not going to let you just go to any mental health hospital that you want on the day that you want. I know, that's weird, right? I know. So just go to the hospital now. All of you just get up and go to the mental health hospital now. That way you're okay if you get arrested tomorrow. Also, I think, and I could be wrong, but I think, what is it? Christmas is on a Monday, I think. That means if you get arrested on Friday, you're not going to see a judge this week for a long time. So don't get arrested this week. Wait until next week or after New Year's. Because when Christmas falls on a Monday, there's no judges. I'm going to try to get more Florida guys too, because they're the best. All right, guys. Have a great night. And I will maybe see you tomorrow. See ya.